for admission. Item number 1.
I hope we can complete it today.
Yes, Your Lordship. I will not take much time, Your Lordship. May I take Your Lordship to page number 32 for a moment, Your Lordship? The FIR
32 of the petition.
of the petition, Your Lordship.
Yes. Page 32.
Paragraph number 6, Your Lordship. Just one line I want to read and point out. Atul Bokria also regularly filed RTI application to the department and tries to get the confidential document from the department, and also filed a complaint before the Enforcement Directorate to malign the image of Nagaland state lotteries. And he has attached the agreement copies between Government of Nagaland and distributor, which is confidential and is not even shared to Atul Bokria even after his repeated RTI application. So this part, Your Lordship, may kindly note. So he had taken out some confidential documents. Then, Your Lordship, page number 33. Paragraph number 9. May I read, Your Lordship?
9.
Further, it is learned from different sources that the above persons are further involved in organizing illegal online lotteries. The Lordship may kindly note online lotteries by various dubious names and most illegally run the same in the state of West Bengal, fully aware of the fact that by dint of Kolkata Gazette extraordinary notification dated so-and-so, the state of West Bengal has banned the sale and marketing of online lottery tickets in the state of West Bengal. In the light of the aforesaid circumstances, we hereby request your good office to kindly take necessary actions against the perpetrators for the offence of dealing with selling illegal paper lotteries in the various parts of West Bengal, cheating public by illegally conducting online lottery draws using their personal computer machines not connected to the central server, and misuse of Nagaland state logo, and theft of imported official documents pertaining to Nagaland state lotteries which were furnished to Atul Bokria, India RTI replies. Your Lordship, these are offences that they have committed, Your Lordship, and this is why this FIR was filed by the informant. The other FIRs that my learned friend is referring to are different, Your Lordship. These are the main grounds why this FIR was filed, Your Lordship. Now, Your Lordship may kindly peruse. They have used fake logo, Your Lordship. And as such, section 482 ought to have been filed when the charge sheet was there, Your Lordship, but 482 is not there. However, Lordship, may I refer to a judgment, AR 2014.
Yes.
I'm referring to paragraph 11, although I'm referring to paragraph 10 and 11, Your Lordship, 9, 10 and 11, I'm only reading 11. In this case, it is not, had Your Lordship gone there? In this case, it is not alleged that the session judge was not followed section 226-227 CRPC before framing the charge. Further, it is not the case of the appellant that the court has not given him hearing at the stage of discharge. For framing a charge under section 228, the judge is not required to record detailed reasons as to why such charge is framed. On perusal of record and after hearing the parties at the stage of discharge under section 227 CRPC, if the judge is of the opinion there is ground for presuming the accused has committed the offence, he is committed to frame charge for such offence, even if not mentioned in the charge sheet. Now, why I am referring to this particular part, Your Lordship, is that the charge sheet fake logo, Your Lordship, 482, section 482 of the Indian Penal Code was not given, Your Lordship. However, in my respectful submission, 482 will be attracted. The FIR itself makes it clear, and the statements of the witnesses So 482 ought to have been attracted, Your Lordship. The case is already charge sheeted, charge has been filed, and Your Lordship, the charge under section 482 may be filed with respect to fake logo, as well as 483 counterfeiting property marks.
482 IPC
And 483.
and
483 IPC, Your Lordship. May I read 482 and 483 for a moment, Your Lordship?
IPC.
482. The charge sheet, Your Lordship, is filed under section 120B, 417, 464, 465, 499, 34, 420, 500, 467, 468 IPC. Here with section 7.3, Lotteries Regulation Act 1888. But in my respectful submission, Your Lordship, 482 and 483 will be attracted. 482 may I read, Your Lordship. Punishment for using a false property mark. Whoever uses any false property mark shall, unless he proves that he acted without intent to defraud, be punished with imprisonment for either description for a term which may extend to 1 year or with fine or with both. And 483, counterfeiting a property mark used by another. Whoever counterfeits property mark used by any other person shall be punished with imprisonment for either description for a term which may extend to 2 years or with fine or with both. So, Lordship, it is very clear that both section 482 as well as 483 will be attracted against the accused persons, Your Lordship, in this case. Although the charge has not been submitted, but the session judge can frame charge against them, Your Lordship. On the last occasion, Your Lordship, an argument was made that Section 500, defamation is a complaint and it's a non-cognizable offence. Now, in this regard, Your Lordship, whether the investigating officer can conduct an investigation when there is a cognizable offence and a non-cognizable offence. In this regard, the case, Your Lordship, I am citing a case law, 2013 Criminal Law Journal, 421. I'm relying on paragraph 4, 5, 6, and 7, Your Lordship.
4, 5, 6,
6 and 7. But I will read from 5, Your Lordship. The aforesaid subsection was introduced in CRPC 1973. This is with respect to 155.2, Your Lordship, to overcome the controversy about investigation of non-cognizable offences by the police without the leave of the magistrate. Under this subsection, if the facts reported to the police disclose both cognizable and non-cognizable offence, the police would be acting within the scope of its authority in investigation both the offences as the legal fiction enacted. Is subsection 4 provides that even a non-cognizable case shall in that situation be treated as cognizable. Now 500 is a cognizable, non-cognizable offence, Your Lordship. The law is now well settled that in interpreting a provision creating a legal fiction, the court is to ascertain for what purpose the fiction is created. And after ascertaining this, the court is to assume all those facts and consequences which are incident or inevitable corollaries to the given effect of the fiction. But in so construing the fiction, it is not to be extended beyond the purpose for which it is created or beyond the language of the section by what it is created. In off-quoted places, Lord Ascot stated, if you are bidden to treat an imaginary state of affairs as real, you must seriously, unless prohibited from doing so, also imagine as a real or the consequences and incidents which, if the putative state of affairs had in fact existed, must inevitably have flowed from or accomplished it. I'm leaving that part, Your Lordship. So, the law in this case, Your Lordship, is very clear. When and then, Your Lordship, 12, in between subsection 4. Had Your Lordship got it? Subsection 4, 12. Subsection 4 of section 155.
yes.
Subsection 4 of section 155 is a new provision introduced for the first time in the Code of 1973. This was done to overcome the controversy about investigation of non-cognizable offence by the police without the leave of the magistrate. The statutory provision is specific, precise and clear, and there is no ambiguity in the language employed in subsection 4. It is apparent that if the facts reported to the police disclose both cognizable and non-cognizable offence, the police would be acting within the scope of its authority in investigating both the offences as legal fiction enacted in subsection 4 provides that even a non-cognizable offence, non-cognizable case shall in that situation be treated as cognizable. From the aforesaid observation made by the apex court, it becomes clear that once you imagine by legal fiction under section 155(4) CRPC a non-cognizable offence like section 500 IPC, and tend with cognizable offences like section 5052 IPC to be a cognizable offence, you must give full effect to the statutory fiction and carry it to its logical conclusion. You should also treat the non-cognizable case as a cognizable offence till the end of the trial, provided that there is a prima facie case for trial, even though there is no complaint from the aggrieved person under section 199(1) CRPC. The fact that the cognizable offence of section 5052 IPC has been quashed by this court earlier is immaterial and is no ground to stop treating the case as a cognizable case and drop the proceeding on the ground of absence of complaint by an aggrieved person. Any other consideration will be doing violence to the legal fiction introduced by the legislature. If the contention of the petitioner is accepted, then it will amount to saying that after investigation of the case, if the facts disclose only a non-cognizable offence, the case must be dropped for want of complaint from an aggrieved person. This should not have been the intention of the legislature in introducing the legal fiction in section 155(4) CRPC. In other words, even after the cognizable offence of section 5052 IPC against the petitioner was quashed by this court, the offence under section 500 IPC will be still deemed to be cognizable offence by virtue of legal fiction introduced in section 155(4) CRPC. An analogy can be drawn from the recent decision of, these are the decisions, Your Lordship. So the law, Your Lordship, is very clear. Assuming there is a case where, in this case, Your Lordship, when there is a cognizable offence and non-cognizable offence, the investigating officer has a right to investigate into the matter. Accordingly, he has investigated into the matter and then filed charge sheet under section 500 also. I am relying on another judgment in this regard, Your Lordship. 2013, AR 1997 Supreme Court 1. This is a division bench judgment, Your Lordship. With respect to the same principle. I'm only really reading paragraph 12, or relying on paragraph 7 to 12, Your Lordship.
7 to 12.
May I read 155(4) before that, Your Lordship? 155 for a moment, CRPC.
Yes.
Information as to non-cognizable cases and investigation of such cases. When information is given to an officer in charge of a police station of the commission within the limits of such station of non-cognizable offence, he shall enter or cause to be entered the substance of the information in a book to be kept by such officer in charge from as the state government may prescribe in his behalf and refer the informant to the magistrate. No police officer shall investigate a non-cognizable case without order of the magistrate having power to try such cases or commit the case for trial. Any police officer receiving such order may exercise the same powers in respect of the investigation, except the power to arrest without warrant, as an officer in charge of the police station may exercise in a cognizable offence. 4 is relevant, Your Lordship may kindly note. Where a case relates to 2 or more offences of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offence are non-cognizable. So in this case also, section 500 is a non-cognizable offence, Your Lordship, but there are other sections which are cognizable, and that is why investigation can be done as per section 155(4). This is what the Supreme Court has made clear. I am reading paragraph 12 again, Your Lordship. Subsection 4 of section 155 is a new provision introduced for the first time in the Code of 1973. This was done to overcome the controversy about investigation of non-cognizable offence by the police without leave of the magistrate. The statutory provision is specific, precise and clear, and there is no ambiguity in the language employed in subsection 4. It is apparent that if the facts reported the police disclose both cognizable and non-cognizable offence, the police would be acting within the scope of its authority in an investigation. Both the offences, the legal fiction entered in subsection 4 provides that even non-cognizable case shall in that situation be treated as cognizable.
Okay, then.
So in my respectful submission, Your Lordship, the offence has been committed and the FIR may not be quashed, Your Lordship. That is my respectful submission.
Just take me to that FIR in Kolkata once.
Yes, Your Lordship. At page
Page.
six, additional affidavit.
Additional affidavit.
Additional affidavit.
Additional affidavit of the petitioner.
Additional affidavit, Your Lordship, a date. Additional affidavit, Your Lordship, it is filed on 8/10/2025.
Then,
Paragraph, page 8, Your Lordship. May I read, Your Lordship?
yes, additional affidavit. Yes.
The instant case has been recorded on the basis of, had Your Lordship, the instant case has been recorded on the basis of letter of complaint dated 27/6/2022, read with report of EO. SNT. A defect of the case is that the complainant is a regular buyer of paper lottery tickets and habitual investor in buying of paper lottery tickets for few years. He used to buy the paper lottery tickets organized by the state of Nagaland, Sikkim, Mizoram, West Bengal, etc. He has mentioned a notification of Government of West Bengal dated so-and-so issued by the Finance Revenue Department regarding prohibition of sale of all types of computerized and online lottery tickets within the state of Nagaland, West Bengal, and on or 21/5/2013. But being a habitual lottery player, he comes to know from that the FIR name accused persons are responsible for organizing, printing, distributing such fake lottery tickets among the members of general public. Their sole intention is to cheat common people by alluring them for their wrongful gains and wrongful loss to the members of common people. The above name accused person has a criminal conspiracy with each other in furtherance to their fraudulent common intention, and their organizing, printing, distributing such fake lottery tickets amongst the general members of public who are losing their hard-earned money in the hands of the accused persons. By these way, numerous consumers have been deceived. The accused persons voluntarily violated the prohibition order of the Government of West Bengal, which was published in Kolkata Gazette Extraordinary Notification dated so-and-so regarding banning of the sale of marketing of online lottery tickets, and thus they managed to siphon huge sum of public money. FIR name accused persons are engaged in printing and manufacturing of fake lottery tickets and also printing prize-winning lottery tickets of genuine and government-authorized lottery tickets numbers which have won prizes, and thereafter encasing the same through lottery vendors, retailers, and the small lottery vendors, retailers also get cheated by said accused persons and lost their livelihood and savings who are involved in sale of genuine government-organized lotteries. Thus, they have alleged committed cheating, forgery, CBT, forgery of valuable documents, and used the same as genuine for the purpose of cheating. Consequently, innocent people are losing their hard-earned money, and accused persons they managed to earn crores of rupees as well as revenue loss to the Government of West Bengal. Thus, they have allegedly committed offence punishable under section so-and-so, under section so-and-so. Read with section 739 of the Lotteries Regulation Act 1988. Now, this was filed. This was by this is one FIR, Your Lordship. Then another FIR is also there. So same contention, Your Lordship. The FIRs are by different persons, Your Lordship. But my respectful submission is, Your Lordship, the state of Nagaland is losing revenue, 1. 2, Your Lordship, they have used the logo of the state of Nagaland. The logo is there in the lottery ticket. Each and every occasion they are using a fake lottery ticket, they are using the fake logo of the state of Nagaland. And it also contains the signature of director, Your Lordship. And in my respectful submission, Your Lordship, I kindly peruse it. Section 177 of the CRPC, Your Lordship, and 178.
Yes.
Ordinary place of inquiry and trial. Every offence can ordinarily be inquired into and tried by a court with whose local jurisdiction it has committed. 178, Your Lordship. Place of inquiry and trial when it is uncertain in which of the several local areas an offence was committed, or where an offence is committed partly in one local and partly in another, or where an offence is continuing one and continues to be committed in more local areas than one, or where it consists of several acts done in different local areas, it may be inquired into or tried by a court having jurisdiction over any of such local areas. So 178 makes it evidently clear, Your Lordship, that the state of Nagaland, Your Lordship, the investigating officer who had investigated upon this case had the authority to investigate into the case, Your Lordship, and file a charge sheet. A charge sheet has already been filed, Your Lordship.
Which court?
In the court of CJM now.
CJM court.
CJM court, Your Lordship. So the investigation is complete. The charge sheet has been filed. So prima facie of the filing of the charge sheet, Your Lordship, there is a case against the accused petitioners, Your Lordship. So in my respectful submission, the FIR that they are praying to quash should not be quashed, Your Lordship.
Is any reply?
Yes, ma'am. Lordship, I'll be very brief. Firstly, Lordship, I would like to differentiate and distinguish the cases that has been referred by my learned friend. First of all, my Lord, the Surrender Singh Rathore, that was AI 2025, Supreme Court. My Lord, this is totally in my support. In as much as this case says, there can be two FIRs, provided it talks about different incidents, separate incidents. But if the incidents are same, if the allegations are relating to the same incident, then two FIRs will not lie. It also talks that if the allegations made in the second FIR or the subsequent FIRs, the ambit of these allegations comes within the ambit of the first FIR, then the second FIR will not lie. Whatever has been said in the second FIR in the Kohima case, my Lord, refers exactly ditto what has been said in the Kolkata FIR. The ambit are the same. Therefore, in fact, this case, my Lord, supports my case. It is based on the TT Anthony's case, my Lord. Secondly, my Lord, the second one, Ukkal Singh, 2004. This is our counterclaim, man. There's no dispute at all. TT Anthony case clearly says that rival versions, rival FIRs is maintainable.
Yes, counterclaims.
Yes, counterclaim is maintainable. My Lord, then again, Udala Satyam, 2025, about clapping. This was by the Supreme Court. Supreme Court in earlier case, Amandeep case, also the same thing has been referred. It was done under 142. Lordship, the Honorable High Court does not have the FIR to clap all the other cases. But in this case, within the state, yes, permissible. That is what the Supreme Court says. But in this case, my Lord, in this case, clubbing of FIR, Supreme Court did not stop there. Supreme Court says, for quashing, go to the High Court. They club within the state, they club it together.
Yes, yes.
But quashing, we don't have. 482 is there, 226 is there. Go to the High Court. Amandeep case also, same thing was said. In fact, in Amandeep case, my Lord, what the Supreme Court did, they clubbed all the FIR together at Delhi, because Supreme Court has the power. Delhi, in different states, all to Delhi, and approached the Delhi High Court for quashing. And investigation also one authority only. That was said in Amandeep case, my Lord. Now again, 1996 is Ishwar Iraji Kalpari. Here, this is a case about Malafadi allegations. That the grounds of challenge in that case was, my Lord, this is a Malafadi, malicious prosecution. My Lord, in my petition, I have said so many things that this is a malicious FIR intended vindictive. But before this honorable court, I have not urged that ground. I have not taken that ground at all.
Yes.
Then, my Lord, Bhajanlal. Bhajanlal is the general principle of
caution.
yes, caution. Then, my Lord, Nihari Infra Private Limited. Here, my Lord, the issue was don't arrest. High Court has directed during the investigation, don't arrest. No such order can be passed. They can arrest. No courtship method should be adopted. That was the Supreme Court said, and that was challenged. Regarding investigation, here, my Lord, I have an anticipatory plea. In this case, Kohima case. It's not about that. Now, my Lord, no violation of CRPC. Investigation is not caution. That's what was argued the other day. I'm challenging the FIR. And the TT Anthony case is based on section 154, 155, 156, all this. And based on that, only one FIR will lie. So therefore, I'm saying that this investigation is against the provision of CRPC as laid down in TT Anthony's case. TT Anthony's case is, after discussing all the section of CRPC regarding investigation, filing of FIR, that case was, the law was settled.
The only thing to be decided is what are the ingredients
Yes.
of all the FIRs. That's
Yeah,
all I have to say.
my
Yes,
lady.
yes, Your Lordship. That is all.
Then, my lord, Chidambaram case. Chidambaram case is about money laundering, Prevention of Corruption Act, and not about double FIR. Deals with the investigation process. And today, my lord, today it was said that this charge, false property mark 483, 482. My lord, since TT Anthony till today, the settle is allegations is made from their different investigating agency may draw different sections. It clearly said they may draw one theft, one may say this is false, fake. But what is the allegation? That has to be looked into, not the offense that is drawn. From one transaction, so many offenses may come up. TT Anthony is very clear. It has discussed that, my lord. Arnab Goswami has discussed that. Everything is clearly discussed. So it's not the offenses, the section that matters. What matters is the allegation. Then, my lord, again, defamation. My lord. Defamation case, 2013 cases has been referred. 2020, my lord. 2016 first. So 2016, the other day I did not give my lord, but 2016, I've not brought the citation, but 2016 is Subramaniam Swami's case, my lord. 2016, 7 SEC 221, paragraph 197.
Just give the citation again.
2016, my lord.
2016.
7 SEC
7 SEC
221,
221.
paragraph 197 and 207.
197 and 207.
No FIR can be filed for criminal defamation. And this was followed in 2020, my lord, Arnab case, Arnab Goswami's case. This is the letters.
Yes.
Now, my lady, regarding the logo, use of logo, yes, where? It was used in the FIR, in the lottery tickets. That means the logo was used, allegation is that logo was used for the purpose of selling the lotteries. So it consists one transaction, selling of the fake lotteries. Logo was imprinted. Just now it also said logo was imprinted. And just now also,
No, these are two different things.
No, my lady.
Selling is different, using the logo is
Logo was painted on the lottery
But
tickets,
still-
which was sold. That is the allegation. Therefore, my lady, if you
that
look
will
at,
form a different offense again.
my lady,
That will form a different offense.
That is also-
Selling is different, but using the logo,
my lord, that offense, that's using the logo in the lottery ticket, my lord. Using it in the lottery ticket to sell the lottery. That is what TT Anthony says, my lord. Anthony, if you read it, because I could like to rely on my lady. Kindly, I'll not read the judgment. Just paragraph
which
20.
one? TTN.
TT Anthony, paragraph 20, my lady. May kindly note. TT Anthony, paragraph 20. Paragraph 20. May I just read this?
1 minute. Yes.
Paragraph 20. From the above discussion, it follows that under the scheme of section such and such only, the earliest of the first information report in regards to commission of the cognizable offence satisfied the requirement under section 154. Thus, there can be no second FIR and consequently there can be no fresh investigation on receipt of every subsequent information in respect of same cognizable offence or the same occurrence or incidents giving rise to one or more cognizable offence. On receipt of information about a cognizable offence or an incident giving rise to a cognizable offence or offences, or on entering a FIR in the station house diary, the officer in charge of the police station has to investigate not merely the cognizable offence reported in the FIR, my lady, but also other connected offences found to have been committed in the course of the same transaction or the same occurrence and file one or more report as provided under section 173. So anything that is occurring there, my lady, is all that comes within the ambit of the first FIR. Now, my lady, the other day I did not give this much, just to clear this point. Babu Bhai, Babul Bhai. Here also, I'll just read paragraph 21 only. Page 265.
21.
Yes, 265. Paragraph 21 only.
Yes.
In such a case, the court has to examine the facts and circumstances giving rise to both the FIRs, and the test of sameness is to be applied to find out whether both the FIRs relate to the same incidents in respect of the same occurrence or are in regards to the incident which are two or more parts of the same transaction. Two or parts of the same transaction. However, in case the contrary is proved, where the version that the second FIR is different, they are in respect of two different incidents, crimes, the second FIR is permissible. In case in respect of the same incidents, the accused in the first FIR comes forward with a different version or counterclaim. So it is regarding counterclaim. So whether it's a part of the same transaction, two or more parts of the same transaction. Then again, my lady, one more, just short. This is Amit Bhai. Paragraph 37. Arnab to Arnab.
Yes, here.
Paragraph 37. This court has consistently laid down the law on the issue interpreting the court that the second FIR in respect of the same offence or different offence committed in the course of the same transaction is not only impermissible but violates Article 21 of the Constitution. In Titi Anthony case, my lord, and same referred again, same follow. My lady again, Arnab Goswami, just one paragraph I'd like to highlight, paragraph 31 only. Arnab Goswami's case that is 2020-14 SSC.
We had read the other day also.
Yes, just this, but just to paragraph 31 only. The court held that there can be no second FIR where information concerns the same cognizable offence alleged in the FIR or the same occurrence or incident which give rise to one or more cognizable offences. This is due to the fact that investigation covers within its ambit not just the alleged offence but also other connected offences. 14, 26. Then my lady just here,
Yes.
54, just to 54.
54 of the same.
Same. Yes. Interpreting this provision, two judge bench of this court in Subramaniam Swamy versus such and such held that neither can an FIR be filed nor can a direction be issued under section 156 CRPC, and it is only complaint which can be issued by a person against this while dealing with the defamation issue. Very clear, and therefore direction was given here, my lady, to the police that the police cannot proceed with for investigation regarding the offence of section 500. That is. Yes, my lady. May kindly come to 61.4. In view of the law laid down by this court in Subramaniam Swamy, we clarify that the above FIR does not cover the offence of criminal defamation under section 119. Very clear. My lady, there is more, but regarding this, whether will be this arising out of the same transaction, even if it constitutes different offences. No need, my lady.
This will do.
No need. My lady, regarding revenue loss, this is not a case for compensation or recovery of the loss of revenue. This is regarding the offence, my lady, this case. So therefore, and it is also not a large interstate conspiracy. All this happened in the state of West Bengal. And is this within the ambit of the first FIR? Whatever offences may be alleged, it is within that ambit. Now, what they can do? FIR is quashed, but that doesn't mean that Nagaland cannot do anything. TT Anthony says they can go, make a statement there, give whatever they have to give, and that will be taken as evidence or statements as under Section 162. TT Anthony says that very clearly. There is, Lordship, that is, it doesn't mean that state cannot do anything. State can go and give their whatever they have in that case, and that should be taken as statements made under 162, and the police can enlarge their investigation on that. TT Anthony says that, but prosecuting a person for the same offences, same allegation at different places violates Article 21, Article 20. I rest my case.
If your Lordship allows me, just one line from the Babu Bhai case, Your
If you
Lordship.
keep
One
on
line.
replying
No,
to
no,
each
no,
other,
no,
it
I'm
will
not,
never-
no, Your Lordship, I'm not replying. I'm just putting out one line, if Your Lordship kindly allows. Paragraph 21 itself, Your Lordship.
Para 21.
Para 21 of AI 2010-12 SCC 254, the Babu Bhai case, Your Lordship. Only one line, if Your Lordship allows.
Yes. Para?
Paragraph 21, internal page 265, Your Lordship. This is with respect to the FIRs. If the answer is in the middle, Your Lordship, 1, 2, 3, 4, 5, 6 line, Your Lordship.
Yes.
Fifth line, sorry. If the answer is in the affirmative, the second FIR is liable to be quashed. This is with respect to the same case. However, in case the contrary is proved, where the version in the second FIR is different and in respect to two different incidents or crimes. Your Lordship may kindly note that incidents or crimes, the second FIR is permissible. So here is a case where there are two different incidents and crimes, Your Lordship. That is my respectful submission, nothing more than that, Your Lordship.
My lady, the other day I have also submitted the list of authorities.
Yes, it's here. We'll see. We'll have to examine
Yes, ma'am. Yes, ma'am.
all the FIRs.
Yes.
Yes, Your Lordship.
Thank you, my lady, for the patient hearing.
We could finally complete. 3 days.
3 days, ma'am.
Heard counsel for the petitioner, Mr. M. Thilanjan. So also heard Mr. P.
Deori.
P. Deori for the state respondents. Hearing is concluded. Order reserved.
I'm very grateful, Your Lordship.
Commission, item number 23.
Yes, have you filed the legible copies?
Yes, Your Honor, we have already filed, but it's still in the filing box. The recast petition.
Oh.
Yes, Your Honor.
Oh, it has not reached the office.
Yes, Your Honor. And Your Honor, I'm appearing on behalf of the main counsel, PJ Deb. He's in this post, so if the matter can be come up on 9 March 2026.
9 March. 9 March?
Oh, that one is not a comment for me, my lord. So that let us fix after 15th of March.
After 15th of March? Who has difficulty? You have difficulty?
Yes, my personal difficulties.
Third learned counsel for the petitioner, Mr. Such and Such, who submits on behalf of the leading counsel, Mr. What's his name?
PJ Deb.
PJ Deb, who has some difficulties today and prays that the matter may be listed on 9th March for admission hearing. Stop here. The learned counsel also submits that the recast petition with legible copies of the documents have been filed. However, the same has not been brought on record till date. So, you'll have to give a copy to the council also.
Yes, Your Lordship.
The recast petition. Stop. At this stage, learned CGC Mr. Zedin Muli submits that he has difficulties on 9th March and accordingly prays for listing the matter on when? 16th?
Yes, my lord.
16?
Yes, Your
On
Lordship.
63. Stop. List on 16.
Item number 4.
16 witness, it seems.
Oblige, Your Honor.
May I please, Your Lordship?
Yes.
Your Lordship, I'm for respondent number 1, that is for a union, Your Lordship. And I've also used the last order.
Yes, yes.
I've also-
So in this, actually, the main respondent is the
Respondent to you.
Narcotics Bureau, isn't it?
Yes, Lordship.
Narcotics Bureau or DRI?
Lordship, I've informed,
DRI, yes, yes. Why the DRI is not appearing?
Your Lordship, I'm for a union, Your Lordship.
Yes.
Your Lordship, I also informed,
They are also your department only.
yes, Your Lordship, I also been informed by the other council that that a notice has already been issued to the RDU. And I've not made any communication to the respondent to Your Lordship.
They are not going to appear.
Your Lordship, I cannot make any submissions on this.
I've informed this yesterday also, Your Lordship. To
They
the
have an
special PP.
engaged in panel council.
Yes, they have their special PP, Lordship.
Where? Dimapur.
Yes, Dimapur. AK Mishra is their special PP, Lordship.
You have contacted him,
Yes, even yesterday, Lordship.
but they are not going to appear.
Yes, Lordship.
Yes, what is the matter? Zima.
Yes, Lordship.
Okay then.
Your Lordship.
You are the owner.
Yes, Lordship. Lordship, by virtue of salary, I'm the owner, Lordship.
Let's see. Wait. You
Lordship,
had
it's-
filed another application before the special judge also.
Yes, Lordship.
Let's see the order of the special judge.
It's at page 22, Lordship.
Page
22, Lordship.
22.
Lordship, here the learned district judge has also admitted that I'm the owner of the vehicle.
Okay, please read this.
Lordship, page number 22, para 2, 1.
No, read from the beginning.
Okay, Lordship.
Heard both.
Heard for the councils and also received the records and satisfied in the incident case the final complaint charge sheet has already been submitted before this court. And on perusal of the record, the vehicle was seized on 14/12/2023 in connection with the incident case, wherein contraband items were recovered from the occupants of the seized said vehicle, wherein the accused petitioner was also traveling and was also arrested in the incident case and has been charge sheeted. It appears prima facie from the investigation report that the seized vehicle has been used in transporting the contraband items. Though the seized vehicle is registered in the name of one Sri so-and-so, however, as per the sale deed dated 12/4/2023, it clearly shows that Smithy, the petitioner, who is one of the accused against whom charge sheet has been filed, is the owner of the seized vehicle. Hence, considering the above facts and circumstances, I do not find any justifiable ground to consider the prayer of the petitions.
Oh, you are also an accused.
Yes, Lordship.
Then in that case, how can it be released? Cannot be, because obviously the vehicle will
Lordship,
confiscated.
here they have taken photographs of the vehicle from every corner as well, from every side.
Later, if you are convicted and confiscated, then it will be difficult to get it back.
They have even rummaged the vehicle.
What?
They have even rummaged the vehicle. They have opened every possible part of the vehicle. They have checked every part of the vehicle.
No, you are an accused. So obviously, that's why the learned special judge has also rejected it.
Lordship, since the law is very clear, which your Lordship is well aware, Lordship. I relied on two judgment, Lordship.
Which one? Ambalal Desai?
Yes, Lordship, and
That is a general law. That is a general
Yes,
law
Lordship, as well as,
regarding Zimma. So that is an admitted fact that it is liable to be released on Zimma, but the facts and circumstances have to be seen. And which one? General Insurance Council.
yes, Lordship.
This is the general law. But when the applicant is the accused, then the court cannot. The present application under section 438, read with 442 of the BNSS, has been filed, praying for release of the seized vehicle Bolero, white, in the bracket white, bearing registration number such and such. You just see from the cost title, okay? Such and such with the ignition key. Stop. The heard learned counsel for the petitioner, Mr. Nisuka Chishi.
Yes, Lordship.
The learned counsel submits that the petitioner is the owner of the seized vehicle bearing registration number such and such, engine number such and such, chassis number such and such, and the same was seized in connection with GR 816/2023, arising out of what is the case number? Arising out of Dimapur case number 03/CL/NDPA/OPIUM/DRI/2023-2024 under section 20 clause B, small 2 C 29, 29 and 60 of the NDPS Act. So, the petitioner's vehicle Bolero mentioned herein above was seized by the investigating agency. Was seized from the on 14/12/2023 and is still lying in the custody of the investigating agency. Stop. It is stated that the petitioner had filed another Zimma application before the learned special judge NDPS, which was rejected by an order dated 24/6/2024. Stop. Being aggrieved, the petitioner has approached this court, praying for release of the aforementioned vehicle pending disposal of the GR 816/2023. Stop. Learned counsel. In that line where I said kept under the custody of the investigating agency, you just say kept under the custody of Directorate of Revenue Intelligence, Dimapur. Directorate of Revenue Intelligence, Dimapur, under bracket DRI, close bracket. A new para. The learned counsel for the petitioner has placed reliance on the case of Sundarbai Ambalal Desai. This you can get in page 8 of the petition. Okay, Sundarbai Ambalal Desai versus State of Gujarat, reported in 2002, 10 SCC 283, wherein the Honorable Supreme Court has stated that whatever be the situation, it is of no use to keep seized vehicles at the police stations for a long period. Stop. It is for the magistrate to pass appropriate bonds and guarantee as well as security for return of the said vehicle if required at any point of time. So, learned counsel further relies on the case of General Insurance Council and others versus State of Andhra Pradesh and others, reported in 2010, 6 SCC 768, wherein it was further held that when vehicles are seized and kept in various police stations, not only do they occupy substantial space, but they are also prone to fast natural decay on accounts of weather conditions. Stop. Relying on the above mentioned judgments, the learned counsel for the petitioner submits that it is settled law that such seized vehicles cannot be kept for long in the custody of the investigating agency, as the same is prone to natural decay and will lose its roadworthiness. Stop. It is therefore prayed that the seized vehicle Bolero mentioned herein above may be released to the petitioner, who is the rightful owner of the vehicle, pending disposal of the GR 816 of 2023. Stop. This court has seen that the notice on respondent number 2, is it?
Yes, Lord.
Respondent number 2 / DRI has been affected. Where is that order? Which order was it?
27/1/26, Lordship.
27. Notice has been effected now on respondent to stop. By order dated 27/1/2026, this court has observed that notice is deemed to be complete upon respondent number 2. Stop. Thereafter, opportunities were given to the respondent number 2 to enter appearance on several occasions. Stop. On 22/2026, also, none appeared for the respondent when the matter was called. Stop. The respondent number 1 is represented by Mr. Such and Such, appearing on behalf of the learned CGC. Stop. However, he has submitted that the main respondent in the present case is the respondent number 2. Stop. Learned counsel for the petitioner also submits that he has contacted the what is he? He is in panel counsel.
Special PP Lordship.
He has also contacted the special PP DRI at Dimapur. However, and has informed him about the listing of the case today. Stop. However, none appears for the respondent number 2 today also. The court has given its due considerations to the submissions made by the learned counsel for the petitioner, and have also perused the records and have also perused the pleadings and the enclosures in the petition. Stop. The order of the learned special judge NTPS no. It was not taken up as a NTPS case.
Yes, Lordship.
If the learned you say principal district and session, but the order only says principal district and session judge.
Yes, Lordship.
The order of the learned principal district and session judge dated 5/12/2024 has also been perused. Stop. From the order dated 5/12/2024, it is seen that the petitioner is also an accused person against whom charge sheet has been filed in GR 816 of 2023. Stop. Even though the accused / petitioner is the owner of the seized vehicle, the learned court below has dismissed the application of the petitioner as the petitioner is an accused. Stop. Para. The general principles regarding interim release of seized vehicles during pendency of a trial, especially under the NDPS Act, is not in doubt. So, the Honorable Supreme Court, in the cases of Sundarbai Ambalal Supra and General Insurance Council Supra, have laid down the general principles that it is not advisable to keep seized vehicles at the police stations for a long period of time. Stop. It is not disputed that such principles are to be followed in normal circumstances. Stop. However, in NDPS cases where the accused himself is the owner of the vehicle, it is very likely that the seized vehicle would be confiscated by the trial court at the end of the trial. Stop. And therefore, this court is of the view that the learned trial court has not committed any infirmity or illegality by dismissing the Zima petition of the petitioner. In view of the facts and circumstances as stated above, the petition is rejected and disposed of.
Obligation.
Item number 5.
May I please, Your Lordship? Your Lordship, I'm again mentioning on behalf of Yang Wadi for the respondent number 1. Your Lordship, despite several reminders to the Ministry on different occasions, we have not received any instructions. However, Your Lordship, we have traced new addresses and we're trying to make a communication to the Ministry through via mail. So if sometime may be allowed to me, Your Lordship. If there is no objection from the other side, Your Lordship.
Regarding the mediation,
Yes, Your Lordship.
Wait,
Automation
wait,
and
wait.
instructions, Your Lordship.
and also the release of the compensation, if you can release it during the pendency, we'll dispose it of.
Yes, Your Lordship. At this stage, we are only forwarding or waiting, Your Lordship. So sometime may be given, Your Lordship.
Your Lordship, if it's
No,
like.
are you disputing?
No,
Are you
Your Lordship,
disputing that the compensation is due to them?
No, Your Lordship, we are only simply seeking an instructions from the Ministry, Your Lordship.
Your Lordship, this matter was filed in the, it's been almost a year now. There's no instruction from the union. The policy.
Now they are saying they
Yes.
have got one email
Yes, Your Lordship.
for communication.
New communications, Your Lordship.
That'd be a last chance then, Your Lordship.
Learned Counsel, Mr. Z. Kono is present for the petitioner. Stop. Learned Counsel,
Jingyang form for Yang Wadi.
appearing for Yangnawati CJC, submits that the instructions are still awaited. No, this instruction will be regarding the mediation or regarding the payment of compensation.
Your Lordship, so far the vetting is concerned, Your Lordship, we have included both the instructions as well as the mediation. Your Lordship, so
That, what did I say? That they is still awaiting instructions as to whether the matter can be referred for mediation, and also regarding the regarding the status of the proposals pertaining to the release of compensation to the petitioner. So it is submitted that an email for communication has been received, and he will be communicating with the concerned
Ministry.
ministry at the earliest. So, Learned Government Advocate Ms. Inahuli is present. Government, state government, nothing to say.
I have nothing to say, but Your Lordship, I've also filed an affidavit, and then due to some technical issues, I have to rectify some documents, which I've already done. So I've filed my affidavit.
But then if they are ready to go for mediation, state government will have nothing to
we
say,
have nothing
isn't
to
it?
say.
State Learned Ms. Inahuli appears for the state respondents, and Mr. Nomusa appears for
R8.
respondent number 8. Who is R8?
Insurance.
Insurance. Okay, R8. Stop. The prayer of the CJC is allowed. List after
3 weeks.
3 weeks as a last opportunity. Okay.
Obliged.
Much obliged, Your Honor.
Item number 6.
Please, Ladyship, here
Yes, yes.
the respondent, for the respondent number 1, Mr. Vikas Sankam is appearing, and then for respondent number 2, we have leader served to the counsel for the standing counsel for the AG. And then we
No,
have,
this one has to be listed before Justice Budi Habung.
my Ladyship, if this is,
Because it may be a recall, but in effect, it is a review.
yes,
Yes, in effect, it is a review. So when it is a review, it has to go before the concerned bench.
Yes, but-
And it's not as if he has retired or, transferred.
Yes.
Since he's still there, it can be, registry will make arrangements to take up through VC also, it's okay. So we can fix a date, you give a date.
it is convenient for me, Ladyship.
Okay. Learned
Subject to
counsel,
the appearance of the other party.
Learned counsel for the petitioner, Mr. N. Mohama is present. Stop. By order dated 13/2/2026, the registry had been directed to place a copy of the relevant rules regarding placing of this IA before the bench which passed the original order. Stop. By office note dated 18/2/2026, the registry of this court has placed the copies of the relevant rules of the Gauhati High Court and the Civil Procedure Code as flagged A and B. Stop. As per the Gauhati High Court rules, the applicant in a review petition has to present the application before the court of whose judgment a review is sought. Stop. In the present petition has been filed for recall of the order dated 21/11/2024, passed in WPC number 139 of 2024, which is in effect an application for review of the said order dated 21/11/2024. So the registry is therefore directed to place this matter before the appropriate bench. So by appropriate bench. After that, you do the needful. If you want to appear through VC, they'll arrange, okay, for doing the needful stuff. Learned counsel for the respondents are absent. You inform them.
Thank you.
Item number 7.
Lordship, pursuant to this Honorable Court order dated 5/2/2026, the accused applicant, he has appeared before the IO on 12th of February 2026, that is last Tuesday. And a bail bond of rupees 30,000 was executed. These statements were recorded. And at this stage, my lord, I pray that the anticipatory bail and interim anticipatory bail which was granted may kindly be regularized. The
Have you
accused
received
shall
any
cooperate.
status report?
No, Lordship. In fact, I had a conversation with the IO today, Lordship. However, Lordship, he's yet to send me the updated CD.
Tomorrow? When can he send?
Can we take it up on Thursday then?
Thursday?
On Thursday, on Thursday.
List on Thursday. In order to enable the learned public prosecutor Vizimoni to obtain the updated CD.
The interim,
The interim order passed earlier shall continue till the next day of listing.
deeply obliged, Madam.
For hearing,
My lady, sorry for indulgence. Item number 10 for hearing. Just a while ago, I have received information from my client that there's some development. Matter may be listed after a week. In the meantime, if I may be allowed to get proper instruction.
Learned counsel for the petitioner, Mr. Mua Jamil, submits that the
Lordship, Your Lordship, I'm appearing on behalf of both the respondents.
Okay,
So,
they are asking for a week's time.
let's say we have already talked in the morning that since as they informed them, there might be some possibility of settlement between the parties. So we have seeking time. So as per our constitution, that it may be fixed on 2nd of March, Your Lordship.
2nd of March. Counsel for the petitioners and who submits that there is some development. There is a development regarding settlement.
Yes.
There is some development regarding settlement outside the court, and therefore prays that the matter may be listed after a week. Stop. Learned counsel Mr. P. Suryan, appearing for the respondents, prays that the matter may be listed on 2nd March 2026. Prays allowed, list on 2/3/2026.
for hearing, item number 8.
May I please, Lordship? Lordship, I beg to mention on behalf of S. Chang, can you list this matter on Thursday?
Thursday. Learned counsel, learned government advocate Ms. Pichani Kita prays for listing this matter on Thursday on behalf of Ms. S. Chang. So, the prayer is not objected to by the learned counsel for the petitioner, Mr. N. Mokammer. Stop list on 26. 26, isn't it? Yes. 26 to. Yes.
For hearing,
I
item
bridge.
number 9.
Yes.
May I please, my lady?
Yes.
My lady, this evening I have been informed by the senior counsel, Mr. B.N. Sharma, sir, that due to his personal difficulties, as he is the appellant in this case, he will be praying for 2 weeks' time.
No, but who's submitting on his behalf? Is anyone submitting on his behalf?
I'm
You?
on his behalf.
Oh, okay.
In
On
fact-
behalf of B.N. Sharma.
Yes, Your Ladyship. Ladyship, in fact, I've been instructed that the respondent has contacted the principal counsel, even yesterday and even this morning, stating their inability to take up the case today. So, or else we were ready.
So it is not B.N. Sharma who's not ready, but you.
No, actually, like I had difficulty on 2nd, so it was a consensus prayer.
Learned
Coming-
counsel Mr. Nomus appearing on behalf of Mr. B.N. Sharma. Prays that the matter may be listed.
Ladyship, it can be fixed on the 9th of March. 9th of March.
Listed on the 9th of March for hearing. So, Learned counsel Mr. V. Debnath, appearing for the respondent, submits that he also has difficulties today, and therefore the matter may be taken up on 9th as prayed for by the appellant. 9th, no?
9th.
List on 9/3/2026. Yes.
Obliged, Ladyship.
Deeply obliged.